Two names on deed, one on mortgage. WHO owns the house? When two names are on a deed but only one is on a mortgage, the deed usually decides who owns the property. A mortgage creates a repayment obligation and a lien, but it does not by itself transfer ownership. That means a person whose name is on the deed but not the mortgage can still have legal ownership rights in the home. In Manhattan, this issue often comes up when spouses buy property together but only one spouse qualifies for the loan. A deed is the legal document that transfers ownership of real property from one person to another. Once recorded, the deed becomes the public record showing who owns the property. A mortgage is different because it gives the lender a security interest in the property if the borrower fails to repay the loan. The lender does not become the owner just because a mortgage exists. This is why the key question is not who signed the loan papers, but whose name appears on the deed. New York recognizes different forms of shared ownership, and each one affects a co-owner's rights. Tenancy in common allows two or more people to own separate shares that do not have to be equal. Joint tenancy with right of survivorship gives equal shares and lets a surviving owner automatically receive the deceased owner's share. Tenancy by the entirety is available only to married couples and includes survivorship protections with limits on unilateral action. These ownership forms matter because they affect whether someone can sell an interest, seek partition, or pass a share to heirs. Two names may appear on the deed but only one on the mortgage because of credit score concerns or income qualification issues. A couple may choose to keep one spouse off the mortgage to secure a lower interest rate while still keeping both names on the deed. If your name is on the deed, you generally have rights of possession, control, enjoyment, disposition, and exclusion. Those rights can still be limited by the type of co-ownership, zoning rules, or other legal restrictions. A deed-only owner should also know that liens can attach to the property and affect all owners, even if only one person incurred the debt. Mechanics liens, judgment liens, and tax liens can all create problems for someone who is on the deed but not on the mortgage. A title search can help reveal recorded claims against the property before a purchase or transfer is completed. Divorce can make these issues more complicated because New York uses equitable distribution for marital property. A quitclaim deed may transfer one spouse's ownership interest to the other, but it does not remove anyone from the mortgage. Refinancing is usually required if one spouse wants to remove the other spouse's mortgage liability after divorce. If your name is on the mortgage but not the deed, you may owe the debt without having any ownership interest in the property. An attorney or lawyer can review the deed, mortgage, and title records to confirm your rights, and another attorney or lawyer can help you address deed transfers, refinancing, or disputes through a law firm that handles Manhattan real estate matters. Avenue Law Firm is located at 505 Park Avenue Suite 202, New York, New York, 10022, United States, and you can call the law firm at 212-729-4090.